Good afternoon, Your Honors. Drew Justice for the defendant appellant Brian Bergmann, and I will reserve 3 minutes.
3 minutes.
Your Honors, I've raised a number of issues in this appeal, but I would submit the biggest way that the lower court erred was in finding liability for a nuisance without making any finding that there was any annoyance or disturbance of anyone, significantly or otherwise, and without hearing any evidence of any such annoyance. What happened in this case was we had two different men who were basically neighbors. They owned large tracts of property, and then they also owned, or sort of jointly owned, a 50-foot neutral zone between the two of them. And on that buffer zone, they had started out as a dirt roadway. Eventually it was converted to a gravel roadway of about 10 to 15 feet in width. Ultimately, in 2008, Mr. Bergmann took some steps to modify the location of part of that roadway. And what he did was the road was undeniable. It was either on his property or, at the very least, undeniably right up against his property. And so what he did was he shifted it over about 20 feet to where it would be closer to the middle of that 50-foot buffer zone.
Counsel, in any of the written materials related to this easement, is there any specification of exactly where within that 50-foot wide easement this 10-foot wide road is supposed to be? Is there any? It's here. It's in the middle. Is that specified anywhere?
There's not. There's not anywhere saying it should be in the middle or on the side or anywhere else. And in fact, the deed doesn't even specifically use the word road or even mention the concept of a road. It just says it's an easement. It's a 50-foot buffer zone that they can use for travel. And so he moved it closer toward the middle of the road. There wasn't any evidence that he was trying to hurt Mr. Hale. There wasn't any evidence that he actually did hurt Mr. Hale.
Did he seek any kind of recovery as part of and they have shared expenses for this easement, for the maintenance of this easement? Did Mr. Bergmann seek any kind of recovery? I just spent this much money or time, effort, and energy moving it.
Well,
I want you to compensate me.
No, that's the thing is, since he was doing it just sort of unilaterally, he just took it upon himself to pay for the expenses himself. So he wasn't charging Mr. Hale for it. He wasn't, and as the proof showed, the movement of it didn't seem to hurt Mr. Hale in any way. A nuisance, according to Jenkins versus CSX Transportation Incorporated, a nuisance is anything that significantly annoys or disturbs someone's use of real property.
Yeah, I know that both parties here have argued the claim or damages awarded here was nuisance, and I appreciate in the memoranda the judge indicated that what happened was a nuisance, but the judgment doesn't say anything about a nuisance. It says damages to the roadway. That, to me, doesn't seem like the judge found a nuisance. Rather, he found exactly what he was saying here, damages to the roadway.
The judgment was just prepared just by opposing counsel just to reflect what was already written in the memorandum. So it wasn't something that was specifically written by the judge.
But the judge signed it.
And it is supposed to reflect his thoughts and work product.
I guess so, but I'm just saying in context that I think the judge had made his thoughts very clear that...
Okay, let's look at his memorandum then. He says, the court finds that the actions of Mr. Bergmann as to what he did to the road in moving it over and in changing its location from the location described in the survey were actionable, constitutes a nuisance, and damaged Mr. Hale. So, I appreciate the word nuisance is used here, but it doesn't strike me, if you combine that with a final judgment, that there is necessarily a claim for nuisance here. He says he's acting beyond his legal right in moving the road. That doesn't strike me as a nuisance type claim.
Well, I agree it doesn't, and I tried to analyze I mean, I tried to analyze the judge's memorandum and his thoughts under
Yeah, I mean,
any
some-
conceivable
I mean,
theory.
And here, I just want to tell you where I think I'm going with this. Is it seemed like to me that the judge was trying to award damages for placing the road back where it was before the alterations had begun.
And that's exactly right. And my contention is that those type of damages are not an annoyance or disturbance as a nuisance would require, nor, as far as I can figure, are they any other type of tort claim or any other breach of contract claim or anything else. For a nuisance, you'd need to show that the road was somehow remade in a bad way or just torn up and not remade, something like that. The judge never found that. The opposing party never testified to that. What the judge did find, in essence, was what you just said, that he awarded damages for undoing the move. The problem with that type of damages, though, is that the reasoning is circular. If there's no disturbance, there's no nuisance liability, and hence no need to move the road back. And so you can't have your only damages be the cost of moving a road back when there's no liability.
Counselor, are you essentially saying there's no right to the road where it was? That there's no tort violation or contract violation or property right violation that's occurred that entitled Mr. Hale to have the road where it was positioned?
That is basically what I'm saying. Again, I would say that if it were remade in such a way to where he was somehow harmed, then I do think he would have some kind of a claim for either trespass against real property or a nuisance.
Despite the fact that there's a cooperation agreement here, so you can just ignore that agreement and place the road wherever you, or make whatever changes in the road you want?
The purpose of the cooperation agreement was because Mr. Hale had fenced off, or at least arguably fenced off, part of I think it's undisputed, he fenced off at least part of the neutral zone. And so the purpose of the cooperation agreement was to prevent future claims of adverse possession by Mr. Hale.
What did it promise the parties were going to cooperate as to, though? Regardless of sort of the initial purpose, what was the agreement that they were going to cooperate as to?
It said that they would cooperate to keep the easement open and to maintain it. It used the words maintain, and it also used the words maintenance. And I understand the opposing side has argued that the word maintain means that it's got to be kept in exactly the same condition 20 years from now that it's in now. But what I submit the common sense definition of maintain there is it's implement maintenance, which is the other word they use. Maintenance meaning upkeep the road. So don't let trees fall over it. Make sure the grass is mowed. Make sure that grass doesn't come up through the road to where you can't travel on it.
You're focused on passability then, the idea that this remains a passable route.
Right, and so they were basically agreeing it was a cooperation agreement to share expenses as well as to avoid future claims of adverse possession. And so by just shifting the road over 15, 20 feet, Mr. Bergmann did not breach any kind of contract, nor do I think was there any breach of contract even pled in this.
Did it make the road less useful in any way? Did it put a curve in there that was difficult to manage? I mean, what?
There was no testimony that it made the road less useful in any way. There was testimony, very briefly, by Mr. Hale that it somehow made the road more curved. However, he didn't ever explain why that was a problem. He didn't elaborate on that at all. He didn't say that annoyed him or disturbed him. And frankly, if you look in the pictures that both parties introduced, I don't really know what curve he's even talking about. It doesn't seem to even be a curve. But the point is that doesn't really, if that were any kind of annoyance at all, that would not rise to the significant type of annoyance that's required for a nuisance. In Jenkins, they talk about how a nuisance is not measured by its effect upon the hypersensitive. And so if all he's got to do is, I don't know, have some curve on this winding gravel road that wasn't already there, I don't see how that's a nuisance. So I did want to also just very briefly touch on this last issue that's where the judge the parties basically agreed years back, like 7, 8 years ago, that they thought they had a settlement about where the boundary lines should be mapped out between the two men. But the problem was their settlement wasn't final in any sense of the word. Their settlement was that they would adopt the written survey that had already been produced by the court-ordered surveyor. But then they said that surveyor would then meet with Mr. Bergmann's surveyor, work out their differences, move certain iron pins or set certain iron pins, and basically get the boundaries right. And in essence, it was just an agreement to agree. And the courts have held in the past
Get the boundaries of what right?
the boundaries of where the 50-foot, because this is sort of what this started
It's the
it all.
50-foot easement.
Right,
that you're marking.
Mr. Bergmann still believes, based on our dead surveyor's advice, that the roadway, as in its present form, is intruding onto his land by about 10 feet. And we've never been able to really get that squared away. We've never had any court ruling on where the roadways are. Again, these two men were supposed to get together and map it out and agree, but they ultimately never did. The record then shows from numerous filings that no agreement was ever consummated, that they didn't follow through with it and come to a final settlement. There was what Mr. Bergmann styled as a Rule 60 motion, even though it was before judgment. There was a supplement to the Rule 60 motion. There was a report from his surveyor outlining their differences. He filed a motion to require the court-ordered surveyor to advise.
So what was all that colloquy at the end of the trial here where the judge was asking about the surveyor not showing up, and everybody seemed to think, well, that's not a problem here. You seem to be saying now, well, that wasn't accurate when that was said at the close of trial.
See, we had initially this was about a year and a half before the trial. We had met with the surveyor multiple times and had tried to get him to finalize his rulings on where the roadway were. And for a while, it seemed as though he agreed with us. And so we were planning to have him appear at a prior trial. But then when we told the parties he was going to testify when we told the court he was going to testify by Zoom at that prior trial, then the other side objected. They said they wanted a chance to interview him and depose him to get his updated readings. And then later he apparently flip-flopped again, and so we didn't wind up calling him. So that's why the judge was confused about why we didn't call him. And that's really all that was. He was very flaky, very unreliable, and never really would do what he was required to do. But I appreciate your Honor's attention. I'll come back for rebuttal.
Thank you.
May it please the court, I'm Bill Reeder. I inherited this case from my partner Gerald Ewell, who got elected sessions judge, and his 6 months expired to wind up before this argument was set. And I told someone the other day, I'm 70 years old. I didn't mean to be working this hard, and if I had my time to go over, I'd be campaigning against it.
Well, I hope you'll send the judge a suitable thank you note for this.
Okay. Your Honor,
So we have this easement, and you have this gravel road within the easement. And one of the parties moves the gravel road a little bit. Is it still in the easement?
I think it is. And Your Honor, I think...
Well, then what's the deal? What's the problem?
Okay, here is the deal. Mr. Hale had worked and created that road that was within the easement. He spent money on it. Shows it in here that he spent over close to $5,000 on gravel. He also used his equipment to grade it and to maintain it and to improve it. He had a property right to that easement that he had created.
He's still got the easement. He's still got the road.
But he had a property right to that road that was within the easement.
It's still within the easement.
It's still within the easement.
Okay.
And contrary to what plaintiff's counsel said there, appellant counsel said, they have had an agreement that road is within the easement. It doesn't encroach on anybody.
Counsel, what's the basis of his right that the easement has to, that, not the easement, the gravel road has to stay in the same spot within the easement that it currently is? Is it a property right? Is it a contract right? Is it a tort right? And what's the right that is giving a basis here for why Mr. Bergmann can't move some gravel to another spot within the easement while maintaining the road?
There is nothing that would prevent Mr. Bergmann from placing gravel in another spot within that 50-foot easement. He could move it wherever he wanted to, his easement. What he didn't have the right to do was to tear up the road that Mr. Hale had built. He had absolutely no right to say, this road has been here, I want to move it, doesn't matter what you think, doesn't matter what all you've done, I'm going to move it. And when he did that, as Mr. Hale testified, just created a mud strip that he had to go back in and fix.
So that's the problem. He had to fix it.
He did.
He did. You're saying Mr. Bergmann did not put the road back into a good, usable situation, and that Mr. Hale had to go in and do some more work on it to fix it.
To get it up to the level where it was before he moved.
Before.
What he did was scrape off gravel. He didn't bring in
So
any
that,
more.
right, that doesn't sound to me like a nuisance claim. So let's talk about damages now.
Okay.
Because for me, the math doesn't seem to add up based on the testimony. And what I think I see that you're arguing in your brief is, well, yes, he testified to, I can't remember, $4,000 to $5,000 or $3,000 to $4,000 to repair the damage that had been done in the easement. He's also recovering here expenditures he made before that date, but that doesn't strike me as what the court is, intended to award here.
I think it was. I think what he did was that he gave him, because of the cooperation agreement, that it said that they would jointly maintain it. Mr. Hale did that and presented the proof of his expenses for that, which was around $4,871, I think, but right there. The court held that that was a disproportionate amount of expenses borne by Mr. Hale, and he allowed him to recover that because a lot of that portion Mr. Bergmann used.
Okay, well,
And then-
so,
Okay.
Counsel, let me just interject here, though. So I'm looking at the final judgment, and I appreciate you did not draft this. This was the gift that keeps on giving from former law partner there. It says for damages to the roadway, he's awarding $8,173.53 for damages to the roadway. I don't see anywhere in the final judgment where he's awarding anything for not keeping up on his share.
I think that's where he got to that figure.
Okay.
It says that, but I think he does in his memorandum state
Okay.
that.
So let me ask you another component about this, and that's about the surveyor, the court-appointed surveyor here. Did your client pay the surveyor and he's getting reimbursed if that's how that worked? Because I was confused by why the court is awarding the surveyor's fee to your client instead of awarding it to the surveyor.
I think that's what happened. I cannot state that. And I think that's why that's in there, Your Honors, but like I say, I inherited this, and I can't tell you exactly why that is, but I think that's the reason why.
Yeah.
He would do that, but even if he didn't, what he's doing is assessing the cost of that surveyor, whether the surveyor's been paid or not, to Mr. Bergmann. If the surveyor has not been paid, and Mr. Hale was awarded the amount to pay the surveyor, then Mr. Hale would have to pay the surveyor from that judgment.
Okay, well then here's the other thing I don't get then, is that he's also awarded your client prejudgment interest on that sum at a fixed amount, why wouldn't that be awarded to the surveyor?
Well, if my client paid that, if my client paid Mr. Elkins,
Yeah.
and I don't think it appears in the record.
Yeah, I was going to say, I've read the trial. I'll just warn you both. I've read the transcript of the trial, and there is no testimony, no proof whatsoever that Mr. Elkin was paid by either party. Now, that may have happened, but I don't know where that comes from.
I don't either unless it happened earlier in a proceeding that was not here.
Okay.
But I would go back to this. If Mr. Bergmann, if Mr. Hale did not pay Mr. Elkins, the surveyor, by being awarded that sum, assuming Mr. Elkins has not been paid, but there could be two scenarios. One where Mr. Hale has paid Mr. Elkins. And in that case, the trial court is awarding Mr. Hale reimbursement of that funds plus prejudgment interest. The other situation is that if Mr. Hale did not pay Mr. Elkins, by awarding Mr. Elkins the amount of that bill, which was, I think, $4,000, and prejudgment interest on that, I think by recovering that, Mr. Hale would be obligated to pay the amount of the $4,000 plus the interest to Mr. Elkins. But it was the court that essentially employed under Rule 706, and he can, under that rule, of that 706 Rules of Evidence, he can apportion that among the parties as he deems appropriate.
Counsel, I want to return back to the damage to the road concept here briefly. In terms of, is there evidence in the record that supports a determination that there was damage to the road that doesn't, moving the road from spot A to spot B within the easement doesn't necessarily qualify as damage, right? And is there evidence that supports the road was in a worse condition in some way, that it was less passable in some way? Okay.
Well, not less passable, but it is in a worse condition.
What would you point us to in the record then to support that there's damage, and the judge may have said the road was damaged? What are we going to see in the record that shows the road was damaged?
Excuse me, I'm sorry. What you would see in the record is testimony from Mr. Hale that the difference of the road was that when he made the road, he cut a 4-inch, took the topsoil off 4 inches, and that he packed it and kept packing it. It was a road. Then if you see photographs of this other road where it was not done in as good a manner, and the grass had started growing from where they had put gravel. Over a period of time.
Are those photographs from before it was
both
moved?
Before and after.
Okay.
The after is where the grass is growing, where he moved it. But Mr. Hale simply put that road back in the same condition. He was entitled to that. Mr. Bergmann had no right, and that's what the court found, either by deed, by agreement, or anything, to go in there and unilaterally say, I'm going to change this. I'm going to dig up what you've done. You've worked on this for years, you spent money on it, but I just decided I want to dig it up and put it over here.
Counsel, was there any negotiation initially when Mr. Hale went and put in the gravel and spot that he did here to create because this was a dirt road, right? And when it was initially, at one point this was a dirt road easement, and then Mr. Hale put in gravel. Was there negotiation for setting where this was going to be?
I don't think so, because I think Mr. Hale built his house there first and then had to build a road to it, and then thereafter Mr. Bergmann came. So there would not have been any initial negotiation on that. It was already in existence. And I would point out, too, that the spot where Mr. Bergmann moved and created, that's what Mr. Hale described as a mud strip, did not inconvenience or pertain to Mr. Bergmann's property, but did Mr. Hale's. But I would come back to the point that Mr. Hale had a property right to what he had done within that easement. And Mr. Bergmann did not have the right to disturb that and damage it, which the court found that he did. And the court found that the damages that Mr. Hale incurred as a result of that was $4,000. And that's based on testimony of Mr. Hale. You know, and he also found that this litigation would not have occurred but for the action of Mr. Bergmann. You know, the question is really not whether moving the road damaged Mr. Hale if it had been done properly. That issue is, what right did he have to disturb what Mr. Hale had done that would result in him having to expend over $4,000 of labor and materials to replace? He had no right to do that. Because I want to move something, or he thinks it might be better to move it, he could have easily done the same thing without disturbing what Mr. Hale had already done. I don't have the right to go to your property when we both have the same right to an easement. I don't have the right to tear what you've done up just to move it where I think it ought to go after it's done.
They both had a right to the easement, but the property right that you say Mr. Hale has is based on their agreement that they act jointly, or what?
I think could be that, but I think the property right that he had the right to construct the road within an easement, okay? Mm-hmm. When he did that, he had a property right to that road because he had expended money, he had expended things of value to create that road, and it was necessary for him to get to his property. And when he did that, even though he had an equal right to construct something within that easement, he did not have the right to tear down what Mr. Hale had already done with a lesser quality and create what Mr. Hale described as a mud strip. That he did not have the right to appropriate the gravel that Mr. Hale had placed on that property and moved it to where he wanted it to go. He didn't have that. He didn't have that right. He took it upon himself to unilaterally move the road, but not just move it, to destroy what Mr. Hale, portions of what Mr. Hale had done.
And Mr. Hale did that because he thought the road encroached on his property?
That's what he said he thought. But that doesn't make any difference either. If he thought when it doesn't.
I'm just trying to understand
Okay. He said
what happened. It's been hard for me to figure this out. I'm sorry.
That's what he alleged. That's what he alleged in his answer, in his counter complaint, that it did.
But there's proof that it did. Did the court make a decision about
Yes, they entered an agreed order that the road was entirely within the easement, the June 5th, I think it's 2015 order.
Okay.
Is that the road as Mr. Hale constructed it, or the road as modified by Mr. Bergmann?
The road as Mr. Hale had constructed it.
Okay.
Thank you. Your time's up.
Yes, sir. Thank you.
On this issue of who had put in work onto the road, I believe it was undisputed at trial that both parties had worked on this road. And so for Mr. Hale to say, it's all my road, that's a little far-fetched. There was some dispute.
Well,
because-
I mean,
because
it's not, you say it's undisputed. Your client testified about these expenses he put forth to maintain the road, but then the judge made an adverse credibility determination against your client. So, I mean, we have to accept that.
I guess that's correct, but I don't think, I mean, they both introduced receipts. I don't think that Hale ever took, even in his testimony, ever took the position that Bergmann did nothing for the road. I think it was basically undisputed that they both worked on it some. The only dispute really was that Hale was taking the position that he disproportionately put in effort, and that's why he was also seeking liability for unjust enrichment. And that's a theory that the court didn't award him any liability on. As far as this breach of contract idea, I still submit there's nothing in the cooperation agreement that has been breached, but even if there had been, I would also point out that the complaint does not raise any claim for breach of a contract, nor did the judge make any finding. Well, he may have made a finding on that, but his finding was clearly erroneous.
Well, I mean, there is evidence in this record that this road had been moved before. And you elicited that testimony from your own client.
Right.
In 91, Mr. Hale came to Mr. Bergmann wanting to move the road.
Yes.
And they did that by agreement. It's on page 35 and 36 of the transcript.
I'd have to look back at it. I know at one point Mr. Bergmann was upset because he thought the road, he wasn't sure, but he thought the road had been shifted over some by Mr. Hale, and he thought, although he didn't know for sure, that it had encroached onto his property. There may have been moves also that they agreed upon that you're referencing. I don't remember that specific page. I would finally point out, though, that there's a good reason why neither the cooperation agreement nor the deed lists any specific place for a gravel road, and that's because why would you have a 50-foot right-of-way in the first place? I mean, there wasn't specific testimony about this, but it's easy to infer that the reason you have that wide of a road is so you can one day let the county pave it over and build a real paved road there, and you've got room enough for that whole road. And so that's why there isn't some specific place where the road needs to be. You just need to be able to access the easement. But anyway, my time is up. Unless your honors have any more questions, I do ask that the judgment be reversed.
Thank you very much. Thanks to both of you. No. You may recess court.